Good evening, everyone. I'm going to get started. I don't want to make people wait. There will be lots of more people joining as we go. Just so you know, I have a couple of law degrees, but one of them is not in how to run a Zoom webinar. So we're going to see how we go. This is my second attempt, and I think we're going to be okay. If you have questions, you can post them in the Q&A box, and I'll try and get to them towards the end. If I don't get through all of them this evening, then I'll hopefully be able to communicate answers to people elsewhere through email. And let's see how we go. Thank you everyone for coming. In case you're not aware, this is a webinar about the Surrogacy Law Review that's underway in Australia. I am recording this webinar and will send a recording link to everyone who registered. So if you have to step away or do parenting things or make dinner, it will be available to watch back later, perhaps at double speed if you like. I'll also publish it on YouTube so it can be shared more widely. And I'll be sharing these slides and some other resources afterwards. Tonight, I am talking to you about the Surrogacy Law Review that's happening over the next year or so and how you can be involved. And tonight we've got intended parents and surrogates, family members and allies, and a few professionals joining. So thank you. It's really good to see so much engagement about the review and interest in making a submission. I will hopefully have some time to answer questions later. If we don't get to all the questions, then I'll find a way to communicate perhaps through email, or I'll do a blog post if necessary, if there's enough questions. I'll just keep track of how many people are getting here. Looks like we've got a good crew so far. Thank you. Thank you for turning up on time. I appreciate it. It's not always a good time for people. 6 o'clock, it's probably witching hour for those of you that have small people. Okay. So if you're here, you likely already know who I am. I was a surrogate about 7 years ago, and I'm also a surrogacy lawyer. I have recently returned from overseas as part of a Churchill Fellowship, where I have been researching surrogacy law frameworks to inform law reform in Australia. So this is quite timely that I get to come back and talk to you about the review. I'm going to give you a bit of an overview of surrogacy in Australia. You might already know some of this information, but it helps to make sure that we're all on the same page. There are only about 130 surrogacy births across Australia each year, and sometimes over 300 babies born via international surrogacy for Australian intended parents. Most domestic arrangements are between friends and family, while a small number are found through social media. And there are prohibitions on advertising for a surrogate in Australia. Surrogacy is altruistic and commercial surrogacy is illegal. If you are a resident in Queensland, New South Wales or the ACT, it is a criminal offence to engage in commercial surrogacy, even if the arrangement is overseas. Now, I'm taking this very slow just to make sure enough people keep coming through. So, meanwhile, over the years, we've seen surrogacy in the news, and often when it's a headline, that spells bad news. There are issues with engaging in international surrogacy, particularly in countries where it's poorly regulated. Many unsuspecting Australian intended parents have engaged in international surrogacy and found themselves in less than ideal situations and had difficulty returning home with their baby. So, how did we get here? And why is there a review, and what does it all mean? In August 2023, it became clear that there was a situation in Crete involving the Mediterranean Fertility Clinic, which included police raids and allegations of human trafficking at the clinic. Quite a few Australians were caught up in the scandal after the Mediterranean Fertility Clinic had attended trade show events here in Australia. When these scandals happen, my phone blows up with the media calling and wanting a comment. In that case, I did 8 media interviews in 5 days and was constantly being asked the same question. Why is it that Australian intended parents are going overseas for surrogacy? And there are a few answers to that question. I think many intended parents find that it's more difficult to do surrogacy in Australia than to go overseas. And over the years, there's been disasters and issues in several countries, starting in India in 2013, And since then, we've had issues and scandals in Thailand and Mexico, Ukraine again, Crete, and Argentina. So I was starting to wonder, where would the next disaster strike? And at what point we would run out of surrogacy destinations before our government would really do something about it. If we are going to complain and wait for the next disaster, we really need to address the issue in Australia. We cannot huff and puff about intended parents going overseas if we are not willing to look at why they're not engaging in surrogacy in Australia. And that's where my Churchill Fellowship came in, which allowed me to travel overseas to find out what other countries are doing and to find some ways to make surrogacy more accessible in Australia. It turns out, though, that the government has also been watching this situation, as you would expect, and shortly afterwards, they announced a review of Australia's surrogacy laws. So what is the review? Just bouncing around screen so I can check how people are going. Oh, good. We've got a good chunk of people now. If you've just joined us, these slides and the recording will be available. So you haven't missed much. I'm just giving a bit of background at this point. So what is the review? The Australian government has asked the Australian Law Reform Commission to review Australia's surrogacy laws. The review is underway and a final report is due to government by 29th of July 2026. Dr. Ronlee Sifris has been appointed to lead the review as the Assistant Commissioner. Ronlee has been researching and writing about surrogacy for many years, so she's well experienced and qualified to do this. And there are what we call terms of reference, which essentially tell the ALRC what parameters there are for their review. It's a bit like a recipe that they've been given that they must follow in order to run the review. These are what you might consider a summary of those terms of reference, which you can see in more detail on the ALRC website. One of the most important parts of the terms of reference is to consider ways to reduce the barriers to domestic altruistic surrogacy. This is the timeline as published on the ALRC website. I have swiped their little image and turned it onto my PowerPoint. We are at the second circle where submissions are being called for on the issues paper. After all our submissions are received, the Commission will consider everything we've put forward. The ALRC will issue a discussion paper in about November this year, and there'll be another opportunity to make another submission to respond to the discussion paper. And next year, the final report will go to the Attorney-General in about July, and then the real work starts with trying to get our government to implement any recommendations of the review, if we agree with them. So what is the issues paper? It's been published on the ALRC website, and you may have received an email from me with a copy, but I'll also be emailing it again later. You can think of the issues paper a bit like an essay paper from Year 10 English class. And I don't say that to scare you, because I realise for some people that would be a problem. That's understandable. But really, the issues paper provides us with some background information, and then there's 27 questions that the ALRC is seeking feedback on. If you think about it like a Year 10 English question, I have a teenager at the moment, so I talk to him about how to answer exam papers. Perhaps focus on the questions that feel easy and that you want to engage with, and you can leave the rest or leave them until later if necessary. So 27 questions, you can answer as many or as few of those questions as you wish. When you make your submission, the default position will be that the submission is de-identified. That means that you can include names of yourself and your children and your partner and anybody else involved, even services that you might have engaged with. And those names will be removed from your submission, and then it will be published for everybody to read on the ALRC website. So I will be able to go in and read other people's submissions, and you'll be able to read mine, but they will generally be de-identified so that we can't tell who it's about. The other option that you can ask for is that your submission can be kept confidential, which means it will not be published at all. So only the ALRC staff will read it, but it won't turn up on the website for other people to read. If you don't choose either way, it will start with being de-identified. If you want it to be confidential, you need to ask for that. So you can write or voice record your submission, whichever you find most accessible and easy to do. And submissions must be made by Friday, the 11th of July. So we've got about a month to go. If you haven't already, it's a good idea to start writing your submission now, even if it takes you several weeks to write, so that you've got plenty of time. There are two important rules for making a submission. These are my rules. Nobody else wrote these. The first one, though, is that your story is really important. So don't feel like you have to write it in a certain way. This is not asking lawyers for answers. They're asking people with lived experience for their experience of surrogacy in Australia and overseas. Your story has a real impact because you are sharing it with them. You don't need to have all the answers. You will see some of the questions in the issues paper are really for lawyers and counsellors and other people to answer. So you don't have to read it and think, well, I don't know the answer, so what should I write? And then make it up. Absolutely, you can leave them blank if you choose. However, part 1 of the issues paper calls for insights from people with personal experience of surrogacy. That's yourselves, intended parents and surrogates, whether it's past, present, future, but also persons born. And if you only answer one question, let it be question 1, which is specifically asking for your personal experience. These have the most impact, and I can talk to you about what's happened overseas with other reviews, but what we find is that when we talk about real people who are impacted by surrogacy, and that includes persons born, then that has more impact on just a lawyer or a counsellor making a submission. If you're not sure, or if it feels a bit overwhelming, for me, for example, I gave birth 7 years ago. I don't remember all the positive and negative about my surrogacy, but it helps to think back perhaps at the different stages and even use subheadings if you like. You can talk about what was good or challenging about the pre-surrogacy process or the pregnancy and the birth, or what was difficult and great, positive or negative about post-birth and the parentage order. And even beyond that, you can use whatever subheadings work for you. If you've gone overseas, you might talk about different avenues that you looked at. You might even look at the fertility and the embryo creation stages as another part. Now, after you finish with question 1, you can pretty much pick and choose which other questions that resonate with you or that you feel like you can make a contribution. One of those questions is question 5. Just a quick check on everything else that's happening. That's good. One of those questions is question 5, which is, what are the main barriers to domestic surrogacy? Now, here's some facts for you, which you can draw on if you like. And when I say facts, some of them are perhaps framed as my perspective, but certainly it is a fact that nearly 80% of surrogacy arrangements in Australia are between friends and family. The vast majority are friends or sisters, for example. And the other 20%, 21% thereabouts, find each other through social media. So if you don't have a family member or a friend, you are potentially amongst all the other intended parents on Facebook looking for a surrogate, which means sometimes that it's easier to go overseas. So that's one barrier. Many states prohibit advertising for a surrogate or for intended parents. So I think that also leads to one of my other points, is that many people don't know that surrogacy is legal in Australia. I think there's a real lack of awareness in the Australian community that you can do surrogacy here and that it is possible and legal. So again, that's another barrier. Compensated and commercial surrogacy is not legal in Australia, and I'll talk more about this, but I do think that's potentially a barrier for people doing surrogacy in Australia because it's very difficult to find an altruistic surrogate. It can seem easier to head overseas. Some countries have services that are willing to help you do surrogacy and to facilitate the whole process, and that can seem easier than hanging around Australia and hoping a surrogate might offer. And of course, if you're in WA, you may be aware that gay couples and single men still cannot access surrogacy if they are residents in WA. And that means, I know for a fact, that some gay couples and single men will go overseas or they'll move interstate. Medical clearance is sometimes difficult to obtain, particularly if your doctor doesn't know much about surrogacy. It can be difficult to find somebody that's willing to give you approval and give you the go-ahead to do that. And of course, surrogacy is expensive. It's certainly not cheap, and I would say that's one barrier for many people that decide not to proceed with surrogacy because it's too expensive. So you can think about all of those ideas and thoughts on what those barriers are, but also consider what are the barriers for you, what would have made it easier for you, what would your consideration have been to do it in Australia, and yet you went overseas. What were those issues? That's what the ALRC wants to hear about. Another one to jump ahead to is question 14, which talks about entitlements and particularly around Centrelink and Medicare and paid parental leave. Many people will be aware, or perhaps not, that Medicare rebates are allowed for fertility treatments, but not for surrogacy fertility treatments. So that's another barrier that means that if you are doing surrogacy, you may have to pay entirely out of pocket for your IVF treatment. We have issues with Centrelink paid parental leave. They do have a policy that allows for paid parental leave for surrogates and for intended parents. But if you want to have a chat with somebody at Centrelink, you will find out that most of their staff are not aware of that, and it can be a real fight to even get that approved. And then, of course, employee parental leave for surrogates and intended parents can also be a bit hit and miss. Most employers do not have a surrogacy-specific policy. And that means that you're just at the discretion of your boss, perhaps. So if you've had experience of Centrelink or Medicare and want to make a submission on those issues, perhaps of how great your employer was in giving you paid parental leave, or that you had a fight with Centrelink, which I know happens regularly, put that in there because it is important for them to see. Now, if you've joined us, there will be Q&A later, so I'm watching the question and answer box. You can put your questions in there, and I will try and get through them towards the end. There will hopefully be enough time to do that. So another question to think about, questions 15, 16 and 17, perhaps some of my favourites. Let's see how we go with this. So question 15 is about the current system of surrogates expenses and whether that could be improved. You might like to consider how surrogates receive their expenses paid in Australia at the moment. It's basically a private agreement between them. But another option to consider would be where intended parents pay their money to an independent third party who manages it and distributes it to the surrogate. That won't be for everyone, granted. It may be particularly with family members that they don't want to do that. But it is an option that operates overseas a lot, and it's often called escrow or trust accounting, where the intended parents put money in the fund, and the fund is then responsible for making sure the surrogate's expenses are paid. So there's like a third party independent person that's managing all of that. Questions 16 and 17 are about compensated and commercial surrogacy. I do have a lot to say about this, but not long enough to talk about it in detail this evening. I presented at the International Surrogacy Forum in Cape Town on this subject. It's a presentation all on its own, but I will say a few things, and hopefully I won't go too long. Number one is that we have an issue of accessibility in Australia, such that there are many, many more intended parents than there are surrogates. There are many more births overseas each year than there are in Australia. One reason for that, I think, is that so few women are willing to be surrogates, and partly because it is unpaid. It is a big ask for someone to carry a baby with no payment or compensation. You might be thinking, as I have done in the past, that surrogates are not motivated by money and they don't want to be paid. And I certainly was never motivated by money. However, we also know from research in the United States that surrogates are motivated by empathy and altruism, even when they are paid. What that means is that being paid does not take away from the altruism of why we become surrogates. It is entirely possible to be motivated by wanting to help people and being empathic and altruistic and still be paid for the work of pregnancy and birth. We also need to consider that arguments against payments focus on the risks of commodifying women and children. And to that, I say that actually even altruistic surrogacy can be exploitative, and that the entire industry, counsellors and lawyers, fertility clinics, even birth photographers, are all paid. But we seem to have a problem with compensating a surrogate and expect her to do everything for free. So a lot to think about there. It is possible for us to have a framework that means a surrogate is compensated for her time and effort, not in exchange for a baby, and what they often call gestational services, rather than being paid in exchange for the baby or transferring parentage. So have a think about that. Question 17 asks what sort of implementation there might be for compensated or commercial surrogacy. Again, I've written about this. You're very welcome to read it. I'll have links that you can go to. It might be that we have a capped payment system paid each month during pregnancy, and that it's regulated, and so that we're kind of avoiding what we see in the free market situations in some countries overseas. You can read my Cape Town presentation. It'll be linked later in one of the slides, and it's on my website. What I would say about that generally, though, is if you're answering this question, you don't have to draft a comprehensive framework for the ALRC. That, again, that's for lawyers and counsellors and everybody else to give that feedback. And the ALRC's job is to come up with what a framework might look like. However, just by saying I support compensated or commercial surrogacy can have an impact. So you can just say that, and maybe, you know, whatever your feelings are about it. And for my part, I would say if you are dead set against compensation, that's fair, that's okay. But I would urge you to think about a bit more about it and consider what are the other options there are to increase accessibility of surrogacy in Australia and to make sure we are not exploiting women's unpaid reproductive labour. So lots of thoughts about that. You could spend hours and hours reading and thinking about it and talking about it. I do recommend that you talk to other people about their ideas. There's no one idea here that the ALRC wants to hear. They want to hear everybody. Question 18 is another big one, and it is around the transferring of parentage. We have issues in Australia where each state has a different process to transfer parentage from the birth parents to the intended parents. And because of that, I think there's barriers then for people engaging in surrogacy. One of the issues there is the costs, and it depends where you live. If you are lucky enough to live in Tasmania, it can be quite cheap to get a parentage order. But if you are in New South Wales, you're looking at least $1,351 just to make the court application, let alone all the fees for counselling and lawyers involved. There's post-birth counselling requirements for some states, but not for others. In some states, there's a lot of paperwork and not for others. It's also generally inconvenient for everyone involved, in my experience, that I've had surrogates that have actually been in tears that they have to keep engaging in this process and doing paperwork and going to court when actually they've got other things they want to do with their lives. And for intended parents, dare I say it, but they're actually at home caring for a newborn. They don't want to be dealing with parentage order paperwork that can, you know, be right next to having to do with Centrelink and Medicare and everything else. So there's also a lot of uncertainty while waiting for the parentage order, particularly if it's delayed. We've had situations, for example, in Victoria during COVID, where children were celebrating their first birthday and there was still no parentage order. And in that uncertainty, we have a situation where the surrogate and her partner are the legal parents of that child, and yet they haven't been raising the child for 12 months. And on the flip side, the intended parents have been raising a child that is legally not theirs. So that's a whole lot of problems, particularly from a legal perspective. And for many children born overseas, it's actually not an option to obtain a parentage order. We have a situation in New South Wales, starting from the 1st of July, that if you are a New South Wales resident, you may be able to apply for a parentage order for a child born through international surrogacy. But the list of criteria is still quite restrictive. It's not an option for everybody, and it still leaves many other children that were born for the rest of Australia who still, their parentage might still be in a bit of a loophole. So have a think about what was your experience of the parentage order. Again, positive and negative. I know that some people really love it. I really loved going to court and seeing my intended parents be made the legal parents of their child. It was lovely. It was quite emotional, but it also took us 10 months to get there. And in that time, I had no care of that child. And I know that my intended parents felt really anxious about the fact that they were not her legal parents for that whole period. So there's some, I guess, good sides to the parentage order process. One option might be that we look at things like a pre-birth parentage order, which they have in some parts, particularly in the United States and in some other countries. This could be that instead of us waiting until the baby arrives, we apply for a parentage order, what's called pre-birth order, before the baby arrives. And it could be a relatively easy process, a bit like what they have in Tasmania, for example, where it's some paperwork that we lodge with the court to say, hey, baby's on the way. Here's our record of having done counselling and legal advice. We'd now like a pre-birth order so that the moment that baby is born, it's the legal child of the intended parents. I think many people might find that a really great option because it means that the surrogate can actually leave the hospital with no parental responsibility for that child. She doesn't have to sign anything for Medicare or Centrelink. She doesn't have to be there for parentage order stuff after the birth. And the intended parents can meet their newborn and start making immediate decisions around medical treatment. And when they leave the hospital, there's no kind of angst around leaving hospital and who's the legal parent and what happens if there's a problem, etc. So pre-birth orders is another idea. I've written about that as well that you can read about, but it might be just generally giving your feedback about what your experience was of the parentage order process. Excuse me. Other ones, particularly for parents that have travelled overseas for surrogacy or people that are considering doing it in the future, is question 20, which talks about citizenship, passports and visas. I think that's pretty self-explanatory. If you have had a child through international surrogacy, it would be great to get your views on what that process was like to leave the country, to get the birth certificate, then citizenship and visas and passports and come back to Australia. I don't know if this has been a problem for many people, but some of the feedback I have heard is that gay couples feel like they may have been treated differently obtaining citizenship and a passport than some heterosexual couples. And that's with the Australian authorities. So if that was your experience, they really need to hear about that. It should be the same for everyone. In terms of how that process could be improved, one option I think is that we should be able to apply for citizenship before a baby is born, even if the application is not finalised. It could be that we submit everything that we can, and then we sit back and wait until baby arrives before we finalise the application. My understanding is that you cannot now apply for citizenship until the baby has a birth certificate, and I think that leads to delays. But there perhaps should be like a surrogacy stream with our citizenship authorities that when a newborn arrives, they kind of kickstart on that process, and then it's much easier and more efficient. Question 24 is about the criminal law and whether or not we have a role in discouraging or prohibiting some forms of surrogacy. Many of you will be aware that it is a criminal offence for New South Wales, Queensland and ACT residents to engage in commercial surrogacy. Whether or not that prevents it from happening, I would say no. And for some intended parents, it is a barrier. They will say, no, we don't want to do this. We're worried about that criminal law. But we know that with close to 400 children born through international surrogacy, the majority of them would be through commercial surrogacy, and that a lot of their parents would live in New South Wales, Queensland or ACT. So is the law working as a deterrent? Probably not. What is the impact, though, of criminalising international commercial surrogacy? We know from a recent case where the parents in Queensland were referred to the authorities for potential investigation, how much anxiety that must have caused for them, but actually also for everybody else that's doing commercial surrogacy. And in the days after that went to the news, I had an inbox full of emails from intended parents saying, what does this mean? Are we going to be in trouble? Now, I think that's not actually conducive with looking after a newborn, and that if our authorities and our lawmakers are really concerned about what's right for those children, they would not be criminalising their parents. And it also doesn't have any impact in that every single case where they have been referred to the police has not resulted in any prosecution. So again, you think, are we just wasting resources to kind of grumble at people for doing something we know they're already doing? So have a think about whether you do think it should be criminalised. I have colleagues that still work in this space and think that it should be criminalised. So I'm not suggesting there's one view, but if you have strong views, this is the time to make a case. I also think what I've learned from overseas is that we need to consider who is being regulated. Is it the intended parents who have signed a contract with an agency who made some nice promises, or is it the agency themselves? And it's very difficult to regulate international businesses, but maybe we need to think about what are we doing to regulate Australian-based businesses who are kind of marketing or selling these products to people. Why are we trying to criminalise the intended parents when perhaps it's the businesses behind them that should actually be more in trouble? Although generally, I don't think criminalising commercial surrogacy is a good idea. And is there anything else that we can do to reduce the instances of intended parents going overseas? I don't know. I think the answer really is not trying to stop them from going, but giving them better options and accessibility within Australia so that they don't feel compelled to look overseas. There will always be, I think, more intended parents than there are surrogates. That is a fact. And there will be those cases where intended parents look at overseas options for all sorts of reasons. But what if we actually had some control over giving them opportunities within Australia so that they didn't feel like they had to go overseas? There's a whole bunch of other questions. Like I say, there's 27 of them. Some of these other ones that you might want to think about include question 10, which talks about the pre-surrogacy process in Australia, whether you have any experiences or comments about it, whether you thought it was enough or too much, whether you liked your surrogacy lawyer or not. Questions 11 and 12 are particularly around surrogacy matching services. I've also written a little bit about this recently. In overseas, we actually have many countries or states in America where they don't really regulate matching services. So anybody can start a service and they can offer themselves to say, oh, we're going to find intended parents and match them with surrogates, etc. And they can make a lot of money out of it. sometimes that works, but in a place where it's not regulated, it does mean that there's no real oversight of the quality of service they're providing. And that can mean that you have somebody that did surrogacy themselves and now they're running a matching service, but they don't have any experience in being a lawyer or a counsellor or even running a business. Now, in New York, I was really excited to find out about their process, which is a fairly new model of licensing surrogacy matching services, which means if you want to start a business providing that service, you have to follow a whole lot of processes to get licensed, and there is some oversight to make sure that the service that you're providing is actually meeting expectations, and that the people that are giving you money and hoping you find them a surrogate are also somewhat protected by those laws. So I have blogged about that. I think it's a good one to think about, particularly again, if we are trying to increase the accessibility of surrogacy in Australia. What does a framework look like where we can have matching services who are actually have that oversight from government and that we know what we're getting? Then, of course, question 2, which I think is like the least controversial of all, is the question about whether or not there's an issue with inconsistent state laws and harmonisation. This is talking about the fact that every single state and territory has a different surrogacy law. I think that all the laws should be the same, and there's 2 kind of potential ways to do that. One is that each state and territory comes to the table and they write one set of laws and then they go and implement them in their state or territory. The other is that we can ask the states and territories to refer their powers around surrogacy to the Commonwealth, and then the Commonwealth makes one set of laws for everybody. There's also WA, which is a bit of an outlier, but that's for lawyers to worry about. So have a think about that. I think the answer to that is, yeah, we want harmonisation. I don't think that's controversial. If you are in any state in Australia, you shouldn't have to worry about crossing a border to access services. Another one is about question 23, is whether there should be oversight, like what we have in Victoria, the Patient Review Panel, or in WA, they have the Reproductive Technology Council. And these are the regulators that make the final decision before a surrogacy arrangement goes ahead. I know PRP in particular has a bit of a bad rap, but there are cases I have come across that I would think have some risks. And if they had gone in front of the Patient Review Panel, then they probably would have been refused. It also takes some of the power from counsellors and lawyers and clinics about who should say yes or no to surrogacy and gives that to the PRP. So if we had like a national one, everybody would have to make an application to that panel or that regulator, the authority, and then they would have final say on whether people go ahead. But they would be focused on the rights and best interests of everybody involved, including the person's born. That's the main focus. I mentioned before lack of awareness and education. In question 25, they want to know about this. So if you went Googling for surrogacy and you came across a Mexican surrogacy agency, and that was the limit to your education around surrogacy in Australia, then it's good to tell the ALRC about that. Where did you get your information and was it accurate? And whether there's a way that the government can actually address that by making sure that the information is front and centre, but that it's credible and unbiased, we have a lot of issues, not just in Australia, but across the world, that surrogacy, the surrogacy industry is full of what we might call conflicts of interest. So it's where an agency refers to a particular service and that service refers back. And you may not be aware that they have this relationship, but you've actually paid for a service and then you're getting compromised advice or services from another one. So just generally, I think we need some regulation around that, but we also need government, I think, to take some control over providing that access to information and raising awareness in Australia. And then there's some questions towards the end around what is out of scope or what are these other issues that they may not have thought about. And one option, this is where even if we make some comments on these issues, the ALRC might say, thank you, but actually that's not within scope of the review, but we should be raising them anyway. And one of those is hospital management of surrogacy. A fair portion of my work is talking to people about how to manage a surrogacy pregnancy and birth at the hospital, and trying to educate midwives and nursing staff and doctors and obstetricians and fertility doctors around how to manage a surrogacy pregnancy and birth and those issues of the surrogate's autonomy versus the right to privacy and the intended parents being in the room and caring for their baby, all of that. So if you've had experience of hospital stuff during surrogacy pregnancy and birth, put that in there, because I think it can be really powerful in terms of telling that story of what was your experience and what was difficult, and what should we be doing to make sure that that doesn't happen again and to give people a good experience of surrogacy care, healthcare in Australia. I think I'm getting towards the end and then I'll switch to questions. These are just some links to articles that I've written over the last year or so. There is a whole lot around compensated surrogacy, including the speaking notes in my presentation from Cape Town. There's a whole thing about matching services and how we could regulate them, a bit like the New York model. Pre-birth parentage orders, I've written about that, and then there's another few just with some ideas around what does surrogacy law reform look like? What can we actually achieve here? So, having a think about why you should make a submission, everyone here has an interest in surrogacy, whether you're an intended parent, whether you're a future surrogate, parents who have already had children, even if it was 10 years ago or 3 years ago, people born via surrogacy. There's even a possibility that if you have a child born via surrogacy, they make a submission, even if they're not over 18. They may want to draw a picture or write their story down. It doesn't have to meet any sort of criteria. They're just telling a story. But also the professionals, including lawyers and counsellors and health and fertility practitioners, should be making submissions. Your submission could help future families. So we have a somewhat transient surrogacy community. People come in, they do surrogacy, they have their children, and then they might move on. Not many people kind of stick around unless they may be like supporting other people through that process, which is amazing. There's a lot of people that move through and they start caring for their children and moving on with their lives. So they may not be making submissions about their experiences, which means it's more important that you make your submission, because you could be sharing your story that reflects a bit on what their experience was as well. So thinking about whose voices will be missing as well, if you know people that have previously done surrogacy, or even people that have thought about doing surrogacy and chosen not to because it was too expensive or there were many other barriers, even telling that story can be really powerful. Thinking too about who else will be making a submission, and I can guarantee you there will be people who are opposed to surrogacy. In the United Kingdom, they had a review similar to this one, which lasted several years. And I spoke to the law commissioner while I was in London, and he said that more than half of the submissions they received were written by people who opposed surrogacy. Now, the good thing is that the terms of reference don't actually allow for the ALRC to really entertain an opposing surrogacy perspective. So it's unlikely that even if we got 500 people saying, I hate surrogacy, you should ban it, it's terrible, that the ALRC will say, yeah, you're right, we're going to recommend that we ban it, because it's not within their terms of reference. However, if there's that many people saying, I hate it, it's terrible, you should ban it, they will have to consider whether that reflects normal community sentiment. And if we've only got 10 people that made a submission that said surrogacy is great, I had a good experience, or yes, I did, it was challenging, but we should change it for the better, but 500 submissions that say it's terrible, they will have to consider whether that's more reflective of the community. So think about who you're writing it for and thinking about who you're trying to oppose in that respect. You don't have to go in there thinking I'm going to fight them all. But in the 2016 review, I read some of their submissions, and there were some people that said, I'm writing this submission because my church asked me to. So there will be campaigns like what I'm doing, trying to get people to write. There will be campaigns on the other side saying you should write and tell people how bad it is. And some of those submissions will be just people that don't understand surrogacy, and they'll be homophobic and awful, and they think we're tearing children away from their mothers. You need to counter that if you're going to give the real perspective. I think a real perspective of somebody that's actually done it or has thought about doing it is more powerful than somebody that just, got told to do it by their friend at the church, for example. So I'm going to switch off this in a moment and go to Q&A. You can see there's a few questions in there. You can start writing now, because it's already open. The submissions have been open for a little while now, and they will close on Friday, the 11th of July. I have created a template, but literally it's just a Word document with the questions in it. So you can use that, and you can delete the questions you don't want to answer. Make sure make it clear that it's your submission and not mine. It hasn't got my name on it. Don't say, Sarah Jefford told me that this is what I should write. That's perhaps doesn't have as much power if it's really your voice sharing that. Share your submission with others, maybe get feedback on it. It might be that your submission helps another intended parent or surrogate write theirs. You can actually combine forces and kind of, nut out your ideas together if you like. I do not have capacity to read other people's submissions or give feedback on them. I'd love to read them, but I don't have capacity to write back and give you edits. However, I'd love it if you told me that you had submitted. You can send me a text and say, hey, Sarah, we submitted ours today. That would be amazing. I'm getting goosebumps just thinking about it. Or you can email me and say we made a submission, and yeah, that would be great. I will publish mine, but I can't guarantee it'll be available for several weeks. I've got a church or fellowship report I have to write, which is clocking on to 12,000 words. So yeah, be patient with me, but you'll just have to perhaps focus on my blog posts if you're actually looking for the sort of things I might say. And then the next round after this is that we wait and see what the ALRC does, but they will issue their discussion paper in November, and that potentially is another opportunity to then make submissions based on what they say about their initial recommendations, I guess. So I'm going to see if I can stop sharing and see how I go with actually being like tech savvy. How good is that? Okay, there we go. Oh, I think it worked. Okay, I'm going to switch over to some questions and see if I can get through these. So somebody's asking, is there any disadvantage of making a submission? Feel very strongly about it after all the struggles we've been through with fertility treatments, but I don't want to face any repercussions for an attempt of contributing to the collective good. Especially when the journey has not commenced yet, we would not want the only last resort we have taken away from us. Hey, well, I'm going to cry. I totally appreciate where you are coming from. I don't think you need to be worried. A couple of things I'd say is that the terms of reference really talk about how can we make surrogacy better in Australia. It doesn't say we're going to ban it, let's look at ways to ban it. So even if your story has been really hard, even if it reflects that actually some of this stuff is terrible, I do not think the reviewers will come back and go, oh, well, they had a bad experience, so now we're going to just say get rid of all surrogacy in Australia. I don't think you need to worry about that. The other thing is that Dr. Ronley Sifris has been writing about surrogacy for many years. I have an entire folder on my computer that just has her name on it because she's written great articles about surrogacy, including about compensated surrogacy. So she's now assisting to run the review. Her job is assistant commissioner, and she's really open to this. I would consider her progressive in this discussion. There's no way that she would come out the end and say, let's ban all surrogacy, even in the face of people saying we should just get rid of it. If anything, they're going to say there's clearly problems with some parts of surrogacy. How do we actually regulate this so that it's better for everybody and that your rights are protected and the surrogate and the child, etc. So I hope that answers the question. Next question I have is that the review is focused on surrogacy, but will it also be looking at egg donation and the costs availability of donors? It's a really good question. There tends to be a significant barrier to those engaging in domestic surrogacy. Yeah, absolutely. We have lots of people that say, I've potentially got a surrogate, but no, can't find the eggs. From what I understand from the issues paper is that they may be interested in that being a barrier, but it won't necessarily come out as a particular recommendation. They're really focused on surrogacy in the terms of reference, but egg donation in particular is part of surrogacy. And I think it would be worth putting in any sort of comments or thoughts about finding an egg donor, what's been difficult about it, transporting embryos or eggs, particularly if the donor gametes from in and out of Australia can be really challenging. And I know that's limited some people's options for doing surrogacy. So yeah, absolutely put it in. Next one is, does the person submitting the recommendations have to provide their contact details? So actually, that's a good question. So I think you kind of maybe will be asked for your email address when you make a submission. What generally would happen though is that for me, for example, I'll put my name and my address and my PO box and my phone number and my email. If they publish that, they will delete all of those details so that it's then de-identified. I'm not too sure if you can make a completely anonymous one, but there's a good chance they'd be open to that. So it might be worth having a look on the ALRC website, but I will also take that question. Just going to write that down because I might be able to find out for you. And I would also say, rest assured, and I did say this at the beginning in case anyone missed it, that you can make what's called a confidential submission. So you can submit it even if it's got your name on it, and only people at the ALRC will read it. They will not publish it on the website if you say, I want this to be kept confidential. So the default will be they get your submission, they take your name off it and they publish it so that it's de-identified. But if you say, no, I don't want that, I want it to be completely confidential, they will keep it, they will read it, they will, consider what you've written, but they won't publish it for other people to read. So you can do either. In some other reviews, they actually have an option to publish with your name and details, or not your contact details, but who you are. They made a decision with the surrogacy review that actually, because we're talking about people's lives and there might be risks in writing something that says, I went overseas and did commercial surrogacy, and that there are children involved here who have not consented to having their stories told publicly. The ALRC just said, let's just de-identify everybody. But like I say, you can have the option to go confidential and not be published. And the next question I think was very similar about posting anonymously. So next one, this might be similar to, I'll just read it out. If you ask for your submission to be confidential, does that mean the submission holds less weight or wouldn't be read by the people that are making decisions? The reason I ask is that my experience is very unique, so even if de-identified, those in the community would know that I wrote it, and I would like to include financial information about costs involved. That is a really good question. And yes, some people will be able to read a submission and go, oh, I think that sounds familiar. That actually, as much as lots of people have very similar stories, there are unique stories that we go, oh, heard that person. So I think you should absolutely be confident that if you make a confidential submission, it will be given the same amount of weight and attention by the ALRC as a de-identified submission. So don't worry about that. You can just make the submission, say, I want it to be kept confidential, particularly if you're putting financial details and other personal, private things in there. Nobody else needs to read it. Another option you can do is do both. And that is that you do a de-identified option to say, this is my thoughts generally about surrogacy, and then do a confidential submission that says, actually, these some specific things I don't want other people to read about. And that might be where you add in finances, for example. You can do either. I also reckon if I don't know the actual answers to this, the ALRC has been very responsive. If I have asked them a question, their contact details are on the website. I think there's an email like surrogacy@ALRC, for example. You can email them and say, what happens if I do this? Will you still give it attention? Absolutely. They're very attentive in all of this. There's a question about, should partners do separate submissions? You absolutely can. Or you might do one as a kind of joint one, but this is my part and this is your part, whichever is fine. You may have different views, but particularly as your experiences of infertility and surrogacy and everything else may be different, absolutely make 2 submissions. 2 is better than 1, I reckon. That's a good idea. Another question. You mentioned at the start of the call that this law reform may have been triggered by an overseas tragedy. I've noticed that Turkey, Argentina, Greece have made reforms or in the process of reforms to make it illegal for foreigners. And then that leaves Canada, which is altruistic, and US, which is very expensive and potentially out of reach. Do you think those overseas shifts have triggered the law reform? I'm not too sure. I had some conversations with some government people maybe last year or maybe the year before, and it was particularly around what had happened in Crete. And they were asking questions of what I thought about the situation was. And it seemed that to me, they had been watching it for a while. I think perhaps they watch what happens on the news, but actually they're hearing it from their own government staff who are saying, hey, we've got a situation in this country where we're being asked to grant Australian citizenship for a child that's born through surrogacy, and we have some concerns about how this came to be. And if you have done surrogacy overseas, for example, in Argentina, I know last year people were finding that their surrogates were being interrogated, or felt like it was an interrogation, by Australian government officials when they asked for Australian citizenship. So I suspect it's not just because I had whinged about it or that we went on the media and talked about it. It's actually that the government is watching this news cycle and going, wait, should we be watching a bit closer? Which I'm grateful for, because I have to say, when we do the media, often if they ask a government official, did you hear about that thing in Crete? They just give a non-response. So if their staffers in the background are paying attention, that's great. I don't know that there was a particular situation that led to that. I do think when we have a situation of children being born overseas and they can see those numbers are growing, there is a responsibility by our government to think about what are we doing to protect children born overseas, particularly if they're Australian, they have rights to Australian citizenship and access to services and healthcare. What are we doing to actually address the fact that they're all going overseas and we don't know that we like that? Yeah, it may also be a bit of a diplomatic thing that they have to kind of justify to the destination country why their own citizens are coming in and doing surrogacy with their women. Yeah. Another one here, excuse me. If we have been impacted by an overseas surrogacy scandal personally, how much detail we should go into? I think you should tell whatever you feel comfortable with. Look, I've got little goosebumps because if you feel comfortable, I think you should say everything. And you can do it confidential if that's what you prefer. Because I don't know that the ALRC will quite understand the issues that have happened in the background. They might know the news cycle, they might know some issues that they hear from, I don't know, Department of Immigration, but they won't hear those personal stories unless you tell them. And your story will still be unique compared to, everybody else that was there at the same time or had children before you through the same company, for example. every week I hear stories about overseas agencies, and some are really good and some are not. And I can't remember all those stories to then put them in my submission. There's not enough paper for me to fill or time for me to do that. So they need to hear it from you. And I can give them a few cases and say, hey, this is what happened. I think you should use it as an example. But actually coming from you is more powerful. So if you feel comfortable, I'm not going to tell people what to write, but if you feel comfortable, then do give as much detail as possible. Yeah. There's another question. Does organising the parentage order pre-birth mean that the birth certificate would have the intended parents on it? i.e., would you only need one certificate and not a new one to be reissued? So it's a good question. One option for the pre-birth order idea is that the pre-birth order would be made, for example, a few weeks before the birth. A copy goes to the hospital, and when they do the newborn declaration or the birth certificate registration, there's it kind of would sit next to the parentage order, so they can say, oh, that's okay, we can put the intended parent on the birth registration, and that goes off to births, deaths and marriages. So all the paperwork's kind of kept together. Some of that's like an admin sort of, how do we manage all this paperwork and educating births, deaths and marriages and hospitals. But I would expect then there would be one birth certificate, and it would list the intended parent or parents on that with the name they've chosen for their baby. Now, some questions have been asked about that, what that means for surrogates, for example, who have potentially been erased from the story. And I know some surrogates feel really strongly. They're like, well, I want to be on the original birth certificate because I don't like being erased from it as if I never existed. And it's a birth certificate. It's a register of this child's birth, not of this register of this child's parents. Just two different things. You could go down a rabbit hole on what the adoption community thinks of that as well, because some people in that community think that we should not be changing birth certificates for an adoption because it's a record of the birth. However, pre-birth parentage would probably have one option for a birth certificate, and it would be issued with the intended parents. There's then that whole question of, well, how do we maintain records of donors and surrogates? And I think there should be a national register. That it means that somebody who was born through surrogacy can access that information about who their donors were and who their birth parents were. But that's actually an ongoing discussion. In Victoria, if you are donor conceived, there is a mark on your birth certificate, but only when you ask for it, when you've turned 18, that indicates that there's more information that you can then go and ask, can I find out about what that information is? It's a complex discussion because some donor conceived people may say, I don't want it listed on my birth certificate. I don't want to be outed to the community that I'm donor conceived. Some surrogates are saying, I don't want I don't want a first birth certificate not issued. I don't want to be erased. Others are like, I don't want to be on a birth certificate. It's weird. I know surrogates' partners are often like, why am I on a birth certificate? I didn't make the baby. So lots of complexity, and also why your view is really important about what do you think? What's your experience of it? Would you prefer there's just one if you're a surrogate or an intended parent? Put that forward. So next question is, do you sense there is an appetite stemming from this review to shift to alignment across the state and territory laws? Yes, I would say when I've had conversations with other people in this context, the number one is we should be harmonising the laws across states and territories. I don't think it makes sense to have different ones for different parts of the country. It would make my job a lot easier without having to think about where are you living and where's your surrogate living and where's the birth going to happen. I also think for such a small country, we have an issue where there's a lack of accessibility depending on where you live, and I think that's appalling. It should be that if you live in Victoria, you are accessing the same laws and treatments as somebody who's in Queensland. I think there's a real appetite for that, and I suspect every person that makes a submission on the kind of supporting surrogacy side will say we need to harmonise and make it so that every state and territory is the same. So we've got two more questions and then I'll probably cut it off, but if you've got follow-up questions, you can come back to me and I will have this recording available. I'll probably put it on YouTube and I'll email it to everybody. Excuse me. So second last question, if you have an answer to a question, but you may not have direct experience, but you do have an opinion on it based on the experience of someone else, such as a friend or someone in the community, are you allowed to mention their experience, but not mention their names, or better not to reference someone else's experience? I think it's okay to mention as long as you're not giving details of who they are. There's a couple of cases I will be mentioning in a confidential submission that does not identify people at all. And in that respect, you might use a pseudonym. I think it's okay as long as you're very clear that this is not your personal experience. You're telling it from an outsider observer's perspective, and maybe you've seen it around the community, or maybe the surrogate or intended parents told you about it, and you have a sense that they may not be making a submission. Absolutely put that in. Again, they're not kind of weighing it up going, is it true or not? They're not looking at deciding who's telling the truth or how much of it is fact or hearsay. They are literally just interested in hearing the stories so that they can then make recommendations based on that. Yeah. Says a question that says, is Mexico safe for Queensland, Australia intended parents to proceed? So that's actually a question for legal advice. You need to speak to somebody about your particular circumstances and whether or not going to Mexico or wherever is a good option for you. So you're very welcome to email me later or speak to another lawyer and get some advice about that before you go ahead. Somebody's saying thank you. Thank you. Thank you so much for coming. There were over 120 people registered tonight, so I'm really excited. Just a reminder that I realise people are busy. I do realise that being asked to write a submission can feel a bit intimidating, especially if you've never written one before. And what you may find is that the ideas start to flow and you write a 25-page submission, guilty as charged. Or you may just go, you know what, I've got a couple of hours today, I'm going to write part of a submission and see where it goes. And even that is helpful. I'm really concerned, particularly from the UK perspective, that they really did campaign hard for the opposing surrogacy perspective, and we need to counter that. I'm not, look, I don't think that's going to be as powerful here in Australia, but it's still a factor. And we can't get to the end and go, oh yeah, I forgot to make a submission, but I can see that everyone on the opposing side did make a submission. It's too late. We've got one real opportunity here to influence change. And I do think that when the reviewers and eventually the legislators are considering recommendations for change, it will be the personal lived experiences that really inform that. What I saw in the UK, but particularly in Ireland, is that they've been campaigning for law reform in Ireland for a long time, for about 10 years. And they have a group called Irish Families Through Surrogacy, and then there's other groups like LGBT Ireland and Gay Dads Ireland. And one of the most powerful things for them was bringing their children to campaign events and talking to politicians with their actual children and saying, this is the impact of you not legislating for surrogacy in Ireland. We have real children that are impacted by this. And one of their main campaigners was a senator, Mary Sirikani, who had a child through surrogacy. So she talked to the media, but also was standing in Parliament saying, this is the real life impact of what your laws do for me and my family and my daughter. So I'm not suggesting you start putting your children in front of the media. That's a pretty big call. In fact, I don't think we should put children in front of the media to prove that they exist. But it does really show that we could have lots of opposing views. We could have lots of views from lawyers, counsellors, other people that are all very varied and based on professional experience. But actually, it's the story that you tell from your heart about your particular situation and your experience and your child and what the impact is. And if you ended up not doing surrogacy, why that was. That's got more impact than anything that I'm going to write. So really impress on everybody to give that a go. And let me know when you've done it. So I'll let you go. Thank you so much for coming. Reach out if you have any questions. I may not be able to answer them quickly, but I reckon together we can do this. Have a good evening, everyone.